Hi, I'm Emily, and I am here with Maya Murphy's attorney, Lauren MacDonald. Attorney MacDonald practices at Maya Murphy's office in Westport, Connecticut, and is admitted to practice law in both Connecticut and New York. Today, Attorney MacDonald will be answering a question about education law. My question today for Attorney MacDonald is, how does the Fourth Amendment apply to my child while at school?
The United States Supreme Court has articulated a clear-cut standard that school officials must adhere to when conducting a search of your child or his or her property. First, school officials do not need to obtain a warrant before conducting a search of your child or his or her property. The need to maintain safety in the school environment at all times outweighs the warrant requirement. Unlike the criminal standard that requires probable cause for a search, the legal standard set forth by the Supreme Court for in-school searches by school officials is reasonable under all of the circumstances. In determining what is reasonable, the Supreme Court has developed a two-pronged inquiry before a search may be conducted of your child or his or her property. First, the search must be justified at its inception. Second, the search must be permissible in scope. So what does a justified at its inception mean? Well, a school official that conducts a search of your child must have a reasonable grounds for suspecting that the search will reveal evidence demonstrating that your child was violating a law or a school rule. School administrators, however, must not abuse this leniency in conducting a search and must do so with reason and common sense. This relaxed approach pertains only if at the time of the search, school officials had reasonable suspicion in conducting a search of your child or his or her property. For example, if your child is acting in a manner indicating that he or she has consumed alcohol or has taken illicit drugs, your child smells of alcohol or drugs, or another student has informed a school official that your child may be engaging in misconduct or illegal activity, school officials will have a justified reason for conducting a search of your child. So if school officials have fulfilled the first prong of justified at its inception of the search will still need to be permissible in its scope. A search will be found to be permissible in scope when the measures that the school official employ in searching your child or their property were reasonably related to the objective of the search, and that the search was not excessively intrusive in light of the age and sex of your child. So first, when conducting a search, school officials must show that the search was related to the object of the search. Therefore, if your child is accused of allegedly possessing or selling illegal drugs, a more thorough search of your child may be permitted. On the other hand, if your child is accused of possessing a bottle of alcohol, a search of her pocketbook or his knapsack may be reasonable, while removal of your child's clothing would likely be unreasonable. Second, the search should not invade the legitimate privacy rights of your child in relation to the search. Taking into consideration your child's age and sex, different search procedures will be subjectively evaluated. For example, a school has been found to have violated a 13-year-old girl's Fourth Amendment rights after school officials believed she allegedly possessed prescription painkillers. Following a search of the girl's backpack, which revealed no evidence of prescription drugs, she was then sent to a nurse's office for a strip search, which further revealed no evidence of prescription drugs. On the other hand, a pat-down of students has been held by courts to be minimally intrusive to the privacy rights of students. Therefore, the means in conducting a search, along with the age and sex of your child, are relevant factors that school officials must consider before conducting a search of your child's person or their property. If you have any questions about whether a search of your child was reasonable under all of the circumstances, feel free to give me a call.